Okay, so Prop 207 is going to be codified under Title 36. You'll all have to forgive me as I continually look at my notes because I want to make sure that I'm giving you the accurate information, and I don't have it all memorized yet. A lot of people assume this is not active yet, won't be active until January. There are some things that have to be worked out, but for the most part, this is active, this is working. As of now, counties are dismissing simple possession of marijuana. They are also dismissing possession of drug paraphernalia that was used for marijuana consumption in line with what Prop 207 legalizes. That's great because we have still been in the state of Arizona prosecuting people at the felony level, even though possession of marijuana and drug paraphernalia could be prosecuted as a misdemeanor. We have still been prosecuting it at the felony level. That really clogs up the system. So most all of us involved in the system, including county attorneys and prosecutors, have been really happy about the concept of being able to dismiss this, and also including judges. I've heard judges say they're happy about getting these out of our system because we have a lot going on in our criminal justice system, and we have more serious offenses that we would like to allocate our resources for. So what has been legalized is that you can possess, consume, manufacture, transport 1 ounce or less of marijuana. This is the marijuana plant, the usable marijuana plant. It doesn't include things that are used to make it edible. Any of those ingredients don't count towards the 1 ounce. Stems, things that aren't usable for actual consumption of marijuana, those do not count for the weight either. So it's just the usable portion of marijuana. In that, no more of that can be no more than 5 grams of that can be from concentrate. So in Arizona, we had marijuana concentrate listed as a narcotic, which increased the level of felony if you were caught with it. So even if you were caught with a small amount of extract or of like a vape pen or anything of that nature, you were looking at a possession of a narcotic drug rather than just possession of marijuana. That increased the level of the felony. You were looking at like class 4 felonies. Depending on the amount, you could be looking at a class 2 felony. And obviously much more serious consequences. So like I talked about with those individuals who were doing those delivery services, oftentimes they were being charged with a much higher class of felony because people enjoy using it in a concentrate form, using it in a pen, consuming it through edibles, all of that because it's in a concentrate form, then was turning it into a narcotic. So Prop 207 addressed that by saying no more than 5 grams in concentrate form. Additionally, you can have no more than 6 plants for personal use. Those plants have to be located at your primary residence, and they have to be being possessed, grown, cultivated for the purposes of personal use. There can be no more than 12 plants at one residence, at a single residence, and there has to be 2 or more individuals there who reside there that are over 21. So husbands and wives, you can have 12 plants, but if you are a frat house with a bunch of frat guys, even though there may be 12 of you who are over 21, you are still limited to only 12 plants, okay? Cultivation needs to be in a closet, in a room, in a greenhouse, or in some other enclosed area that's equipped with a lock or security device. So that means you can't just grow it out on your patio, can't grow it out just in your regular garden. It has to be locked somewhere. Additionally, it has to be in a place where the plants aren't visible from public view without using some sort of binoculars or an aircraft or something of that type of optical aid. So that means that you can't have it right there sitting in a windowsill. You've got to put it somewhere where it's not visible to the public. Obviously, if it's in a greenhouse that's locked up, but you can fly over and see it, that's still legal. Okay, you can transfer 1 ounce or less of marijuana, of which no more than 5 grams is concentrate to any individual over the age of 21. So that means if you want to share some marijuana with your friends, you can do that, so long as it's only 1 ounce and no more than 5 grams of it is concentrate, and that individual is over 21 years of age. Additionally, and important to note, like I said, this is the area, I told you there's an area where we can run into the same issue that we had with medical marijuana. You can't get any sort of payment for it. You can't get anything of value for it. So you can't trade for it. You can't get $20, you can't get a gift card. You just have to give it. So if there's anything more than just giving it, now we're talking about potentially sales of marijuana, which is a higher class of felony. So you want to avoid that. No selling it. No giving it for anything of value. Let's see here. You can transfer up to 6 plants to someone who's over 21 years of age. Again, you cannot get any money for it. Additionally, I should have mentioned this, you can't advertise that you're giving marijuana away. So that means don't try and sneak around this and put something up and saying, hey, I'm giving away free marijuana, and then work out some sort of payment on the sly. That's not going to work for you. If it's advertised, that alone is enough for it to be a violation of this, and at that point in time, then you could be looking at some potential criminal consequences with that, because you're no longer under the protection of Prop 207. Same with the plants. Somebody over 21 cannot accept anything for it. It can't get paid for it, and you can't advertise it. Additionally, paraphernalia. So that's anything that you use to consume marijuana is now no longer illegal. So you can't be charged with a misdemeanor or felony for possession of anything that was used to consume, cultivate, keep marijuana. So paraphernalia goes all over. I mean, any drug offense has a paraphernalia charge with it, because anything related to that then becomes paraphernalia. If it's in a wrapper, that's paraphernalia. If it's in a baggie, that's paraphernalia. If you have a pipe with residue, that's paraphernalia. That is no longer illegal. So that is fine. Again, it is only for individuals who are over the age of 21. So essentially we're looking like with alcohol. Okay. Also, a new point that's important is the odor of marijuana no longer constitutes reasonable suspicion for a search. Now, this has been something that's been changing over time since we legalized medical marijuana. Initially, an officer could come up to a vehicle, claim to smell some marijuana in the vehicle, and would then be able to stop and search because of the odor of marijuana. That eventually changed, and if the individual had a medical marijuana card, then that no longer constituted reasonable suspicion, because they could have the odor of marijuana around them after legally consuming medical marijuana. So that changed. Now, the issue was then, but if you didn't have a medical marijuana card, it still constituted reasonable suspicion. Now, it no longer is carte blanche to constitute reasonable suspicion to initiate a search. This is really good because it was allowing officers to initiate searches of homes on nothing more than I smell the odor of marijuana, and that often led to great invasions of privacy and what most of us on the defense bar would consider a violation of individuals' constitutional rights. So that no longer applies. However, if the investigation is for a DUI, that smell could constitute sufficient reasonable suspicion to not search, but engage in a DUI investigation. Why? Because you still can't drive impaired on marijuana, okay? That being said, we also had a nice change to how the DUI laws work. what they changed related to DUIs is that now if somebody is arrested and charged for driving under the influence of marijuana, which would be an impaired to the slightest degree now, because it's no longer an illegal drug. It's not driving under the influence of an illegal drug, but you'd have to be impaired to the slightest degree. What that then changes is that the state now again has the burden to prove that the individual is impaired. Not just that the individual consumed marijuana, but that the individual was impaired. Let me explain why that's so helpful. What we had experienced with the Medical Marijuana Act was first still having DUIs almost automatic for somebody who had a medical marijuana card and had an active metabolite of marijuana in their system, because there's an inactive metabolite, meaning that it doesn't have any effect on you, and an active metabolite, meaning it is affecting you. Now, an active metabolite doesn't mean that you're impaired. It just means that the active component of the marijuana is actually working, the THC is working in your system. That doesn't necessarily mean that you're impaired by it, however. That changed to then you needed more than just the active metabolite for somebody with a medical marijuana card. The court said, no, you got to have more. And what they then changed it to was, if there is a DUI, there is an active metabolite of marijuana or THC in that individual's blood, but they have a medical marijuana card, then so long as the state can prove there's an active metabolite, then the defense has to prove that the defendant is not impaired. That's really unreasonable, honestly, because you are asking a defense attorney or a defendant to prove a negative, prove non-impairment. It's not something that's actually possible. I'm sure you've all heard this. You can't prove a negative. So that was a function of the law that was problematic. So now we have legislated and to correct that problem, that the state has to prove what it should have always had to prove, is that if you have marijuana in your system legally, that you are impaired. In other words, you are presenting some sort of danger to other people because you're impaired in your ability to drive a vehicle. Makes sense. That's the way it always should have been. It wasn't, but we have now legislated that to correct it, which is really awesome. Other things about this that are important for you to know. Anyone who is under the age of 21 who possesses, consumes, or transports or transfers without money, in other words, you provide marijuana, you're under 21, you provide marijuana to somebody else without them paying you, because again, if they pay you, that's sales. We're in a different situation. You could still be charged with the felony there. But without paying you, and you're under 21, and it's 1 ounce or less of marijuana, no more than 5 grams of concentrate. So that's just the constant here. 1 ounce, no more than 5 grams of which is concentrate. That individual would be guilty of on the first offense, it would be a civil violation, so it would be a civil penalty. So similar to like if you get a traffic ticket, that's a civil violation. It's not criminal. You are not convicted of a crime, and you would have a penalty of no more than $100 and 4 hours of drug education for your first offense. Excuse me. For your second offense, if you're under 21 and you're possessing, it's a petty offense. Now, that is a criminal offense, but it's a petty offense, so that's even lower than our lowest level of misdemeanor. And you have to attend up to 8 hours of drug education. If you have a third or more, it gets up to a class 1 misdemeanor. So that's the highest it can go. But obviously, a court can impose higher penalties up to the maximums for a class 1 misdemeanor, which is 6 months of jail and $2,000 in fines if you have 3 or more offenses in which you are under 21 and you are possessing marijuana. Similarly, we also have, if there is a possession of marijuana for somebody who is over the age of 21 and they have more than what's allowed, the 2.5 ounces, and not more than which is 12.5 grams of concentrate, they are then guilty of a petty offense. So again, not a high criminal offense, but still a criminal offense, the lowest level of criminal offense that you can have. You're not able to smoke in any public place. That's important for you to know. If you are smoking in a public place or open space, then you are guilty of a petty offense. A open space is something like a public park, public sidewalk, public walkway, or public pedestrian thoroughfare. So somewhat of a sidewalk still. If you cultivate outside of the statute, so you're growing something and it's not within what the statute allows, then your first offense is going to be a petty offense. Your second or subsequent offense, so your third, fourth offense, is going to be a class 3 misdemeanor, which is your lowest level of misdemeanor offense. So cultivating over it, that means that you have more than the 6 plants that you're allowed to have, or you have more than the 12 plants that you're allowed to have with 2 or more individuals living there, or you're cultivating outside of your residence. All of that can get you to a petty offense and then a class 3 misdemeanor. If you are under the age of 21 and you lie about your age to get marijuana, you present a fake ID, your first offense is a petty offense. Second or subsequent gets you up to a class 1 misdemeanor, the highest class of misdemeanor. Again, the penalties for that go up to $2,000 in fine, 6 months in jail. So don't lie about your age, wait till you're 21. If you're under 21 and you attempt to purchase marijuana or a marijuana product, marijuana paraphernalia, not paraphernalia, marijuana product such as like an edible, something of that nature, then you are guilty of a petty offense for your first offense or a class 3 misdemeanor for your second offense. Next, delivery. We've talked about this already as to medical marijuana and how that was being done. Delivery is to be done by marijuana establishments. Delivery is not available at this point in time until there are rules adopted and regulations, and that is only for marijuana establishments. Marijuana establishments are established based on the rules and procedures that are then put into place to gain the title of a marijuana establishment, similar to like having a liquor license. That's kind of the process that we're looking at here. If somebody is delivering, once those rules are adopted, if somebody from a marijuana establishment is delivering and it's not in compliance with the rule, they are looking at a civil penalty of $20,000. So we're not messing around. Arizona's legalizing this, but we're being really strict on it. Make sure you're following all of the rules. Anyone who is not a marijuana establishment that facilitates delivery of marijuana or marijuana products, solicits or accepts orders for marijuana or marijuana products, or operates even a forum for individuals to solicit orders for marijuana or marijuana product. So that means you operate that website and you let other people do it. You're still in violation of the Medical Marijuana Act. You can't even operate that website or a listing service related to the sale or delivery of marijuana. So this is going back to the concern that they had. We spent all these resources with the medical marijuana on trying to stop people from delivering to other card holders. If you are doing that and you're not a marijuana establishment, you are subject to a penalty of $20,000 for civil fine per violation. Now, let me also clarify this. This is only talking about a civil penalty. This does not mean that because there's a civil penalty, you could no longer be subject to the criminal penalties for selling marijuana if you are not a marijuana establishment. I want to make that really clear. So if you think, oh, well, I'm going to make enough money I can eat the $20,000 civil fine. You're still inviting, and especially if you're selling enough, that a $20,000 civil fine for each violation is not a problem for you. If you're selling that much, you are looking at potentially being charged with a high-level felony for the sale of marijuana. And even though we have somewhat pulled the concentrate from being a narcotic drug in the sense of if you're within the confines of this act and what it allows, that we're no longer considering it a narcotic drug, the concentrate. When you step outside of the protection of this act, that opens the door for the state to charge you still with a narcotic possession, narcotic sales. So don't step outside, okay? It's a big risk, and it's not necessary when we have it legalized as we do. The next part that is really exciting and is also spurring on some great conversation for some future criminal justice reform that I'm really excited about coming in this next legislative session is expungement. So we don't have expungement in Arizona. I get that question a lot. You cannot expunge a conviction. It does not matter how long it's been. It doesn't matter how silly it was. It doesn't matter any of that. Outside of juvenile convictions, which are sealed, you can't expunge, seal any conviction in the state of Arizona. It is always public record. The only time that you can seal anything as an adult is for an arrest. If the arrest was wrongful, then you are able to convince a judge that the arrest was wrongful. And in that case, that doesn't just mean you were not guilty of the offense or found not guilty of the offense or not charged with an offense. It means that the arrest was fully wrongful, did not commit the offense at all. Then that can be sealed. All right. So now we are talking about expungement. We have our first statute that allows us to expunge an actual criminal conviction and arrest. This, starting in July of next year, will allow you to get your record expunged for any arrest, prosecution, or conviction of possessing, consuming, or transporting 2.5 ounces of marijuana, usable marijuana, or less, of which no more than 12.5 grams is concentrate. So that's what you get to expunge. So that's really great. It includes also anything that involves the plant. So anything that's legal under Prop 207 for you to do now, if you were convicted of it in the past, you can expunge that record. You can expunge the arrest record, the prosecution record, and the conviction. So what happens with that, how that process works, excuse me, is that you file a petition with the court, and the court then orders those records sealed for different agencies, so long as you fit the bill for this. And the state has an opportunity to respond to that. So myself, as well as other criminal defense attorneys, we're geared up to assist you with that. If you've had a conviction for marijuana and you want to talk to somebody about whether or not you qualify for expungement, please feel free to contact me. I'm happy to talk to you about it. I've drafted up petitions for that already that I think will comply with how the courts want that done based on what's in the statutes, though there may be still some guidance that we get going forward. So this is really exciting news. I know I'm kind of like nerding out on this, but it is a good step for us here in Arizona. Like I said, not just for the fact that people who want to consume marijuana can do so without fear of a criminal penalty, but we have wasted way too much on marijuana. Way too much money, way too much time, way too many resources. We are now pulling that back. What that means for those of you who couldn't give a rat's ass as to whether or not you can consume marijuana or anyone can consume marijuana or not, is that this has opened up an avenue for those resources to be reallocated to places where they are needed. That's something to always think about when we move things along. Even if you're not pro marijuana, you don't have to be excited about the passage of this proposition, this bill, this proposition, because what it does is it will help make your community safer. It will limit the amount of criminal activity for the sale of illegal marijuana because it's legal now. It will stop us from spending so much time on these silly offenses and people, college kids who are smoking pot, so that we can then actually reallocate those to things like on college campuses. Date rape, that's rampant in college campuses. We'd like to spend more time on that. Other serious offenses that we have out in the world. So overall, yay, very excited about the passage of Prop 207. Feel free to reach out to me if you have any questions about what we discussed here. I'd be happy to talk to any of you. Thanks so much. Bye.